Good evening, friends. I'm a lawyer also. Hence, I have passion to discuss about some important legal judgments. They are called as precedents. One of the most important cases, which is a landmark judgment in the annals of Indian judicial history, is what's called as Kesavanand Bharati Swamiji case. There was one Shri Kesavanand Swamiji Sri Padangalavar who was in a state of Kerala. There was a dispute between him and the state of Kerala. Ultimately, this case went to the Supreme Court. This judgment or this case is perhaps na bhuto na bhavishyati. An important landmark judgment like this was never delivered in the past in our Indian judicial history, and perhaps it can never be done in future also. That's why I said na bhuto na bhavishyati. It has carved a niche for itself in our constitutional history. This is called as His Holiness Kesavanand Bharati versus State of Kerala. How many judges heard this? A record number of 13 Supreme Court judges and the constitutional bench, they heard this matter. How long did the arguments last? 66 days. Ultimately, the verdict was delivered on 24th April 1973. Ever since this landmark judgment was delivered, the judiciary is well aware of the fact that only certain things in the acts can be amended. There were some judges who were favoring that government could amend any part of the constitution, any act, etc. The parliament could amend anything. No. The ultimate decision was that the basic structure of the constitution can never ever be amended. Who were the famous legal luminaries who argued for this? For the petitioners, we had N.A.Palkhiwala, very brilliant, authoritative legal luminary. In fact, we know that after every financial budget declaration, N.A.Palkhiwala used to go to Brabal Stadium in Bombay and he used to immediately address a mammoth crowd of 20 to 30,000 people who were gathering in Brabal Stadium to listen to his words of wisdom regarding the new budget, etc. Such a brilliant legal luminary. He was the main person arguing for the petitioners. And he was contending that basic structure of the constitution can never ever be amended. To assist him, we had another very equally capable, brilliant Parsi advocate by name T.R. Andhya Rujina, who were the counsels for the government, who were trying to defend that government has got powers to amend anything. We had then Attorney General Mr. Nirinde and another very brilliant yet another Parsi legal luminary, H.R. Sirwai. When the hearing began, the history goes that for about nearly 1 month, the Attorney General Nirinde and H.R. Sirwai were keeping pin drop silence to each other. They never talked to each other for about nearly 1 month. Such was the tussle between Sirwai and Nirinde. Ultimately, this led to superstition of certain judges. Justice A.N. Ray, who was trying to favor the government, became Chief Justice of Supreme Court, who were superseded. Justice Shilat, Justice Grover, Justice K.S. Hegde, who later became Speaker of the Parliament, is none other than the late father of our esteemed Justice Sri Santosh Hegdeji. These judges were superseded and A.N. Ray became the Chief Justice. Another Chief Justice of India then, Hidayatullah, had remarked, I vividly remember, I quote, today we do not have forward looking judges, but we have judges who are looking forward to become Chief Justice. Unquote. Hidayatullah was referring to the behavioral pattern of Justice A.N. Ray, who ultimately managed to become Chief Justice of India. The basic structure of the Constitution, which was ultimately declared as the final thing in this verdict, what does it mean? It means there is supremacy of the Constitution. Constitution is supreme. Scope for judicial review should exist. The secular character of the Constitution shall prevail. There should be a separation of powers between legislature, judiciary, and executive. The federal character of the government should be preserved. The republican and democratic form of government shall exist, and there will be unity and integrity of the nation. These were some of the characteristic features which the various Supreme Court judges told in their judgments. Another most important characteristic feature of a basic structure of the Constitution, it is also called as Doctrine of Basic Structure. It is that there should be a close harmony existing between our fundamental rights and directive principles of the state policy. Remember these three important things: supremacy of the Constitution, judicial review, harmony between directive principles of state policy and one's fundamental rights. These things can ever be amended by any government which comes to the power for another decades and decades or centuries. This basic structure doctrine shall remain, it shall prevail. That's the importance of Kesavanand Bharati Swamiji case, the judgment of which was delivered by the Supreme Court, 13 judges. Basic structure has become an axiom of constitutional law, if I can say so. It's a proverbial statement. It's a colloquial statement. It's an axiom. In mathematics, we have axioms. Similarly, in legal language, it is an axiom of constitutional law. Basic structure, basic structure, basic structure. This is akin to certain other classical US Supreme Court judgments, wherein there was a political overlay also. I mean, these judgments came because of some political disharmony or political chaos, whatever I call it as. Three judgments I can recollect. One, Marbury versus Madison in the year 1803. Other, Dred Scott versus Sandford, which year? 1856. And now the latest, Brown versus Board of Education, delivered by the US Supreme Court Recently, perhaps in 1954, I was only 1 year of age when this landmark judgment was delivered. I was born in 1953. So, my friends, uh, this is a very important judgment uh, because a lot of legal stalwarts have toiled day in and day out to get this fantastic judgment. This basic structure of the Constitution can never ever be amended by any act of the Parliament. That's why Indian citizens are very, very safe. Our fundamental rights are guarded. That's the greatness of our Constitution. That's the greatness of this country. It will not be out of context if I can say that when the hearings were being held at the Supreme Court, lot of rift, a lot of tensions, lot of arguments, lot of quarrelsome behavioral patterns between Palkhiwala Sahib and then Attorney General Nirinde. It used to occur. Ultimately, Palkhiwala won, and Palkhiwala was very free, frank, fearless legal luminary. He did comment on the irresponsible behavior of Advocate Attorney General Nirinde. He did comment on this, and he did convey this to the constitutional bench then also. So, my friends, remember Kesavanand Bharati Swamiji versus State of Kerala. It's a very, very important landmark judgment and verdict delivered by our Supreme Court. I have told you which other judgments of US Supreme Court simulate this particular decision of Kesavanand Bharati Swamiji. We are happy, we are free citizens, our fundamental rights are being guarded only because of this classical judgment and because one brilliant legal luminary, Shri N.A.Palkhiwala ji. Hats off to Shri N.A.Palkhiwala. Thanks a lot for watching this video on the legal aspect, and if you like it, please like it. Share it with your friends, share it with advocates, with your fellow judges, companion judges, brother judges. Not that they are not aware of it, they are aware of it, but just to refresh their memory. And these videos I am making for non-legal professionals also, be it a doctor, be it an engineer, be it a public spirited person, they will gain knowledge about this doctrine of basic structure of the Constitution. Thanks a lot. All the best. God bless you.